Initial meeting of the House Select Investigative Committee concerning the complaint lodged by Representative Ford Carr will come to order. The purpose of today's meeting is organizational. That is, to review the rules that will govern the proceedings going forward and to set forth next steps. We will not be discussing the substance of the complaint or possible defenses. First and foremost, we will expect and insist on decorum. We will insist that it be strictly observed by all participants and the audience. Any hint of disturbance or behavior unbecoming of the Kansas House of Representatives will be met with swift action by me, and if necessary, the person or persons responsible will be removed from the proceedings. Second, after reviewing the pertinent rules and some precedents, I have concluded that the Select Investigative Committee proceedings are primarily legislative in nature. However, they also borrow some features of judicial proceedings. So as we move forward, the way we will proceed could from time to time diverge from what we're used to in our legislative committees. The rules and customs observed in those committees will, however, be our primary guide. To further explain the somewhat unique rules, I have asked Revisor Gordon Self to briefly review them for us. Mr. Self, a lawyer, is head of the Kansas Revisors, a group of exceptional lawyers who daily assist the legislature as we draft, debate, and vote on bills. Mr. Self not only has a long tenure as a revisor and head of that office, but also has advised several other select investigative committees over the last 10 years or so. He is the committee's legal counsel and advisor in this matter. Please draw near and give your attention to Revisor Gordon Self.
Thank you, Mr. Chairman. I'm Gordon Self, Revisor of Statutes, and I was asked to give a brief overview of the process and some of the requirements that will be guiding us. First and foremost, I think it's most important to start with the fact that the Kansas Constitution makes it very clear that each House shall provide for the expulsion or censure of members in appropriate cases. Those are the exact words from the Constitution. So I think from that, what has been historically significant and precedent for this body is simply that the process, the responsibility, the duties are with the House to make decisions regarding its members when there is a complaint, in this case, raised. It is this House and this body that is responsible for that. Now, how did we get here to this particular committee? That constitutional language is very broad in nature and gives the House its discretion to set up whatever procedures they would like to deal with matters that involve the House. And I'm very serious when I say that. The House deals with its members, not the Senate, not the legislature as a whole, not the courts. At this juncture, this is a House matter to be decided by the House. In the House rules, there is Article 49, which is specifically related to reprimand, censure, or expulsion of members. And it provides the process that you should follow as a part of this. Now, once again, as I go through these, you're going to see that there's not a lot of detail, and so that allows discretion to this particular committee as it moves forward, both from the standpoint of the chairperson, but also as the body as a whole. Now, there is some experience from other times that complaints have been filed and select committees have been formed, but you know, obviously each complaint, each circumstance, each legislature, each House is different. And so you will be You may be aware of precedent, but at the same time, my best advice to you is that you will establish your procedures going forward that best suit the matter at hand. The first part of this is Rule 4901 deals with a complaint. And it says that each member has the right to lodge a complaint against any other member of the House requesting that the member be reprimanded, censured, or expelled for any misconduct. They need to, in order to do that, they need to file a written statement for such complaint with the Chief Clerk, Susan Kennard. In this case, that was done. A complaint was filed with Susan, and Susan then forwarded it to the Speaker. And the purpose of that is, under the rules, the Speaker is required to appoint a select committee for consideration of the complaint. And obviously, that's what's been done, and that's why you are here today charged with that responsibility. The requirements with regard to that are simply that the committee should be comprised of an equal number of majority and minority party members, and that's what's occurred here as well. The next part of the rule, which we're now in Rule 4902, the next part of the rule states that the select committee, and this is what I was saying about you have some discretion to set up your structure and how you'll proceed. But it does indicate the select committee may dismiss the complaint after the inquiry, or they may set the matter for hearing. And so that's the decision of this body, how to proceed at this point. Ultimately, if the matter is set for hearing, there are not specific rules in the House rules with regard to how you proceed, and frankly, in the past, the select committees have taken different approaches, and so that will be up to you, the chairperson, and you as a body. Ultimately, you would have the responsibility to make decisions, hear evidence, hear testimony, as broad or as limited as you choose, and then ultimately, the one requirement that is listed in the rules, that is that you must give reasonable notice and an opportunity to appear shall be afforded the member complained of at any hearing held. The committee does have the investigating committee powers that are in KSA 46-1001 et seq. You may exercise, utilize those powers, or you can conduct yourself as a more traditional House committee. And the chairperson alluded to the fact that that was the primary goal, but in reserve is some of the powers that have been afforded this committee that may be of a more formal evidentiary nature. That will be up to the body to decide how to proceed. The rules goes on to state, upon completing the hearing and deliberations thereon, the select committee may dismiss the complaint or make recommendations to the full House for reprimand, censure, or expulsion. And keep in mind, this is a little bit analogous to a standing committee in that this body will not be, let's say, levying any determination and punishment if decided. This committee will simply be, if they believe something should be done, they will be recommending to the full body. It's only the full body that has the authority under the Constitution and under the rules to order reprimand, censure, or expulsion. And that does require a 2/3 vote. So this body at this point, if they decide to go on and hold a hearing, they would have the option to dismiss or make recommendations to the full body. In the past, the select committees in the past, there's been varying results, and so reports have been moved to the full House. At the same time, there's been dismissals of complaints as well. So from a precedent standpoint, there's been a varied result. So with that, I'm being fairly brief because I think the two things to keep from this is the Constitution gives you this authority, and you have this authority and this authority alone. And then secondly, I've delineated the specific rules that you must adhere to, but beyond that, you have discretion through the chair and your body as to how to proceed.
Thank you. Are there any questions from the committee of Mr. Self? Yes, Representative Francis.
Thank you, Mr. Chair. Thank you, Mr. Chair. And you may, I understand that precedents may not be our primary concern here, but if I remember from an earlier hearing in this nature, a letter was issued to a representative for misconduct. Was that approved? I don't remember that that was approved by the House. I thought that was maybe sent by the committee, and then that the body was made aware of the letter.
That's correct.
And so in that case, was there an actual dismissal of the complaint, or how was that part handled?
There was what I would call a letter of reprimand. Reprimand isn't specifically mentioned in the Constitution. The Constitution mentions censure and expulsion, but reprimand is in the House rules. A letter of reprimand was issued delineating the concerns that the committee raised and specified the misconduct, and then basically said, we're going to take this under advisement. If there is further action, an additional complaint will be issued, and there may be more severe action recommended. Because censure and expulsion are specifically listed in the Constitution, you know, it is my opinion that only the House as a whole could act on that. Reprimand isn't specifically mentioned, so in that particular case, as I told you, I believe the Select Committee has discretion. That Select Committee recommended that they would issue the letter of reprimand and make the House aware of it. They could have recommended reprimand to the full body and had the full body act as well.
Yes, Representative Ballard.
Thank you. Just a clarification. I think in addition to that, the letter also stated what they would recommend, whether it was to go for counseling, that you have a mentor, is a commendation. So I think all of that was included. So, but I don't remember if it was in the one letter or was it a following letter?
Representative Ballard, you're correct. There was, so to speak, conditions that were included, and it was included in the letter.
Okay. Thank you. Just wanted to make sure.
Yes, Representative Amix.
Thank you, Mr. Chairman. Mr. Self, will you or a member of your staff be at all of our proceedings?
Yes, I will be at all your proceedings, and so will Jill Walters, first assistant.
Okay, and if I have one follow-up.
Sure.
Thank you, Chairman. So you say that we have discretion as a committee to be able to, for these proceedings, but you will steer us to make sure that, you know, we're not straying from rules or Constitution, anything like that?
Yeah, I'll give you some help.
Thank you. Thank you, Mr. Chairman.
Just to emphasize that, he is our committee's legal advisor, and we will take his advice.
And I know you know this, but I want to state it. My office is nonpartisan. We would be giving advice with regard to procedure and the statutes and rules. Ultimately, you would make those decisions, and neither I nor Jill would be involved in any of the recommendations or anything like that.
Right. Thank you for that clarification. We will, as a committee, make substantive decisions about punishment or not, The revisor will be helping us with procedure to make sure, as you said, that we're following the rules. Are there any other questions by committee? No? All right, thank you so much, Mr. Self. We appreciate your experience and wisdom in these matters. So now going forward, I'm asking the two parties to this proceeding to submit to me via email by close of business or 5 p.m. Monday afternoon, that is March 1st, a list of witnesses you intend to call, as well as copies of any documentary evidence you intend to present. If you intend to use any tangible items other than documents as evidence, please describe them in your submission to me. Upon receipt of the information, I will be in a position to determine scheduling for the next meeting. I'm hopeful that the proceedings will be completed by the end of next week, but that will depend largely on the information I receive from the parties on Monday. With that, the meeting's adjourned.